Hi, everyone. Welcome to today's episode of Vine's Let's Get Growing podcast. My name is Justin Withrow, and I am the dental-focused attorney practicing at the law firm of Flannery, Georgalis. I'm based in Cleveland, Ohio, but our firm has offices all over the Midwest and East, and it's my pleasure to talk to you today. I have made a career of representing dentists and dental practices in a variety of regulatory enforcement matters, whether it be insurance audits or board investigations, criminal investigations, and then just general disputes that can occur in the day-to-day operations of a practice, whether you're having issues with a partner or associate, issues with a dental lab that you may be utilizing, or sometimes we run into issues after acquisition or sale of a practice regarding disputes between the buyer and the seller. What inspired me to practice law in the dental industry really originated from my working alongside another lawyer in a representation of a dentist in a criminal matter approximately 12 years ago. My colleague was formerly a practicing dentist turned lawyer, and he did not have much experience representing dentists in enforcement matters and in criminal investigations. His practice was more so focused on contract negotiations and general corporate matters for dentists and dental practices. So we worked together representing a dentist here in Ohio that was under criminal investigation by both, the federal and local county government. And it was there that I realized that dentists didn't have, a strong foothold in the legal marketplace where there were lawyers that really prioritized representing dentists in, the enforcement matters that they can frequently face, throughout the duration of their career. I don't really know why that is necessarily, but I think it has to do somewhat with that, the reimbursement rates and the dollars involved in dentistry aren't as high as, other areas of healthcare. And so when lawyers are representing healthcare providers, they may not necessarily prioritize representing dentists and dental practices. I've always enjoyed doing it because I think it's an opportunity to really develop a long-standing relationship with a provider and a practice, and be that go-to legal resource for them, during the duration of their professional career. Can I share a notable case or legal matter that illustrates how dental law significantly impacted a practice or the broader dental industry? So my most notable case and how it impacted a particular provider was in my representation of a provider in the Midwest. They were under criminal investigation for allegedly billing for services not rendered. And it's more so how the case originated than how the case ended that is particularly noteworthy. So one morning, the doctor received a call from their office manager in the early hours before patients had started to arrive, before the doctor was even at the office, and informed that approximately 50 FBI agents were conducting a search warrant at the practice. They were taking computers, they were taking paper charts, they were taking other, business records, and they were essentially making the practice inoperable from that point forward because all of the necessary business resources were being confiscated by the FBI. That FBI search warrant execution turned into a years-long criminal investigation of this particular provider, again, for allegations that they were billing for services not rendered or they were upcoding certain procedures. And it was through my representation of this provider that I learned that, there are certain investigators that just simply don't understand the dental industry, don't understand how coding and clinical decision-making of a dental practitioner really works. And so through our representation of this particular provider, we were able to successfully challenge the government's notion that our client was billing for multi-surface restorations and a variety of other services that had never been performed. And the way we were able to do that is by compiling records from subsequent providers that had treated these patients. And these patients were minors. So they were younger individuals that, generally speaking, at one point or another in time, had to visit an orthodontist. And one of the great things about orthodontic practices is they love to take photographs. And so these photographs were very helpful to us in proving that services had been rendered and disproving the government's allegation that the services had never been provided, and the client was just billing for services that he didn't actually perform. This proved to be such a strong strategical tactic that the government ultimately decided to close its criminal investigation, and we ended up resolving the matter that started with a 50-agent search warrant execution at the office with a $90,000 civil settlement for some various improper coding related issues. There was no suspension of the provider's license. There was no closure of the practice. And thankfully today, this provider is back to work and operating a thriving practice in their community. I'll always remember that case, and I'll always remember how important the intraoral photos were to really saving this practitioner's livelihood. And it's something that I recommend to all providers now, is to incorporate into their clinical process the taking of intraoral photographs, because you just never know when an x-ray or the clinical record just doesn't tell enough of the story. And an intraoral photograph can quite literally be the difference between criminal investigation and no investigation whatsoever. An emerging trend or regulatory shift in dentistry that I think all providers need to be mindful of is regulators' increased use of audits as an enforcement tool. So audits are an insurance company or government agency or government contractor's way to scrutinize post-payment, in most circumstances, services rendered, billed, and paid by a provider in a practice. And these audits can range anywhere from educational only all the way up to demanding repayment of hundreds of thousands of dollars, referrals to licensing boards or prosecutorial agencies, and removal from participation in networks. Now, obviously, there's a large gap between educational opportunity and criminal referral, and most audits tend to land somewhere in the $20,000 to $50,000 recoupment. And really, audits are designed to ensure that practices are complying with the contractual terms and the coding guidance that is required. So every provider that is in network, or even those providers that are out of network, agree to comply with the coding, documentation, and record keeping protocols of the insurance companies that they're billing. And these audits are the insurance company's way to ensure that that compliance is being adhered to. And when auditors find that the documentation, record keeping, and at times the clinical decision making and standard of care rendered is not up to their standard, that's when they seek to recoup money. And it's become such a prevalent enforcement mechanism in dentistry, I think more so in dentistry than other areas of healthcare, that all providers need to really understand, the basics and the how-tos, if you will, of what to do if you ever receive that letter that you've been selected for audit, or an insurance company is requesting patient records from your practice for scrutiny. So how do I approach helping dental clients, whether solo practitioners or large practices, understand and prioritize compliance and risk management without it overwhelming their day-to-day operations? I think that's one of the nice things about working with counsel, where we can ideally serve as that compliant arm of a practice so that the provider and the owner can focus on the day-to-day operations of the practice. They don't have to worry about the compliant aspects of the practice. They can outsource those to myself or other compliance-based dental consultants to ensure that the practice is operating compliantly. Now, I always think it's a best practice that a practice identifies someone. Usually it's the owner or another provider, but someone that can serve as the compliance officer for the practice. And there's lots of different ways that dental practices can, utilize compliance and make sure that they're operating compliantly. I think a good place to start for any size organization is to review the general compliance program guidance that was released by the Health and Human Services Office of Inspector General in November of 2023. So HHSOIG, which is the federal healthcare fraud enforcement arm of the government, released guidance materials for healthcare providers operating in the healthcare space in terms of best practices for implementing or creating compliance programs within their specific business. And because healthcare entities can range from solo practitioner to multi-location, multi-site operations, there's a lot of variety in what that best practices can be. The nice thing about the guidance from HHSOIG is there's specific guidance that's tailored towards those small entities where it could be one provider or one or two providers and a handful of administrative staff. Because obviously what's going to work from a compliance program standpoint for a mega organization that's multinational or multi-state is not the same that will be possible for a small solo or handful of provider operation. And so there's a lot of fluidity and flexibility in what best practices are from a compliance standpoint. And I would encourage everybody listening to this podcast to, Google HHS OIG General Compliance Program Guidance, review the document. I think it's roughly 90 pages in length, but it's broken out depending upon the size of your organization. And measure your operation to the guidance from HHSOIG. Are there areas where improvement is necessary? Do you feel like you're doing things generally consistent with the recommendations that they're making? And if help is needed, you certainly can reach out to, a healthcare lawyer like myself or another consultant that, prioritizes and really focuses on working with providers and practices on compliance and compliance-related issues. If I could give one piece of advice to dentists and dental professionals to grow their practices, what would it be? And I'm going to go back to that word compliance. From my perspective, growth needs to be focused on providers and practices that have a healthy and compliant underbelly. And so what do I mean by that? I mean that from an administrative perspective, from an operational perspective, everything is operating compliantly. We are doing things in adherence with insurance contracts and state and federal law. We're periodically monitoring to identify whether improvements are necessary, either our coding and documentation practices are necessary of improvement, or a particular provider needs additional training and education on a particular area of practice, or our front office staff needs some training and education on how to better handle insurance billing and administration, handling of appeals and denials, whatever the issues are. Growth should always come hand in hand with strong operational, strong clinical, strong administrative practices. So I look forward to continuing this conversation and getting more in depth on August 18th where I will be appearing on Vine's webinar, and we'll get more into how providers can operate compliantly, what those insurance audits can look like, how practices can best prepare themselves if audited, and then what audits can look like if they do occur and if they do find, particularly adverse findings. Thank you all for listening, and I look forward to seeing everyone again on August 18th.